Emefiele, Bawa, Kanu, DSS. Right? On Channels TV's website, it is captioned, Emefiele's rearrest legally procedural, says DSS. You can check the other ones. No, it's on the Punch. It's on different dailies for today. But I'm going to go with the one on Channels and probably read from the one on Vanguard. And then we would start. I have a guest. I'll introduce my guest shortly, but let's just have a background to the conversation. I told you I'll tell you a story. So So the spokesperson for the Department of State Services, Peter Afunaya, has described as legally procedural the rearrest of suspended governor of the Central Bank of Nigeria, Godwin Emefiele, on July 25, 2023. After Justice Nicholas Uwebo of the Federal High Court in Lagos granted the embattled Apex Bank chief bail. Now, in a piece on Monday, Afunaya said, contrary to attacks against the DSS, the secret police obeys court orders. Afunaya also said that the DSS obtained a detention order from a magistrate court for Emefiele to continue to be in the custody of the secret police. Now, the service had long issued a press statement over the incident that happened at the court between its staff and those of the Nigerian Correctional Service and pledged to investigate it, he said. Though the investigation is ongoing, the preliminary findings are quite shocking considering the ignoble roles played by some public officials. Now, the DSS spokesperson said Emefiele was rearrested on the basis of adequate suspicion of commission of a crime. As normal with criminal investigation, security agencies rearrest suspects when there is adequate suspicion of commission of a crime or as may be revealed by an ongoing investigation. Emefiele was rearrested on the basis of this, even though the rearrest was tainted by the overzealousness of personnel of the service and NCOS, that's the Correctional Service. It was nonetheless legally procedural. Afunaya added, many had gone to town with stories of DSS flagrant disobedience to court orders, especially in view of the last episodes at the high courts in Lagos and Abuja. With what played out at the court on the 27th of July 2023 under Justice Edward Okpe, the service immediately applied and obtained a detention order from a magistrate court. So Emefiele is legally detained. For reasons that Emefiele's case is sub judice, the service will refrain from making further comments on the subject matter. Now, whether on Emefiele, Bawa or Kanu, that's Nnamdi Kanu, the service has obeyed judicial orders and handled the cases procedurally and in accordance with the rule of law. Critics are encouraged to be a bit more discerning and up their research capabilities. Doing so will reveal that the service obeys orders. Now, the Court of Appeal judgment on Kanu is recommended for detailed study. Maybe we can decipher the difference between discharged and acquitted and what the use of either or both mean in the final order of the judge. The DSS is an ardent respecter of the law. Anyone may argue this, but it is true. It is in this regard that it is applied for either a stay or notice of appeal on some of the matters. One who does not obey the laws will not resort to legal procedures like the DSS has done, Afunaya said. So my guest is Henry Ekine, who is the National Legal Advisor for the Committee for Defense of Human Rights. Okay, I finally got him on the phone. I was trying to reach him. So yes, it's the National Legal Advisor Committee for Defense of Human Rights. Henry Ekine is a lawyer, so I can call him Esquire, I guess. Welcome on the show. Welcome.
Yes, Scalata, thank you for having me. It's my pleasure.
All right, so you must have seen the report, the DSS saying it obeys court orders. And remember the last time you and I had a conversation, it was about the DSS. And I remember telling you that in the case of Kanu, they had gone to the courts to ask for an appeal, and it was mentioned in that statement made by their spokesperson yesterday. But what has brought you to this conversation today is the part where they said that they are detaining Emefiele is legal and they went through the right processes. So I want to get your thoughts on that. Remember the court granted him bail to the tune of 20 million naira, and they went to court the next day asking for the permission to detain him further, but the court declined. I don't know if you remember as well. But now they say that they have gone to a magistrate court to get a detention order. So I'd like you to educate me in legal terms, legalese. Tell me, what do you make of this?
Yes, until the DSS spokesperson came up with this explanation, what had been in the public was what we had known.
All right.
So, but let's put in context whether that kind of procedure exists. Yes, it does. The Administration of Criminal Justice Act, which of course the Department of State Services, more appropriately the State Security Services will use, but also exists in states as the Administration of Criminal Justice Law, enables a situation where arresting authorities having a suspect in custody could approach a magistrate's court upon application for an order to detain a person, perhaps pending investigation, so that they would not have to hold that person in their custody, such arresting custody beyond the constitutional limits. So that is a window that is available under that law. But until the spokesperson of the State Security Services spoke about this, we really wouldn't have known if they actually had approached the magistrate's court to obtain such order of detention, to remand the person in the correctional center or in their custody. But again, what I know is that even such application, I've always said that it is in rare circumstances that any court, whether it's a magistrate's court or a high court, that would order the remand of a citizen, a Nigerian, in custody of any of the arresting authorities, other than the correctional service center, custodial center. Because what is usual, even as I know, is that any arresting and detaining authority approaching the magistrate's court for that remand order is usually granted, if at all, for that suspect to be remanded in the correctional center, not in the custody of the applicant in most cases. So that's, again, will not really absolve AFRIA to the effect that they were to hold or justify to hold Emefiele in their custody. So if they approached the magistrate's court, and more appropriately, the magistrate court, if satisfied upon that application, which is not automatic and express, would order that suspect be remanded in the correctional service center.
Now, can I ask a question? The magistrate court and the federal high court, which has got a higher status?
The federal high court expressly.
Okay, good. So
the hierarchy of courts in our judicial system, the hierarchy of courts in our legal system, the high courts are higher than the magistrate court, whether it's state high court, federal high court, or the high court of the FCT.
If a magistrate court, if the high court says you've been granted bail, and then the magistrate court gives permission for, remember that they had gone back to the high court after they claimed to have new reasons to rearrest him, and then the high court said no. I mean, you understand, remember the reports then, and then they decided to go to a magistrate court to get an order of detention. Is it not conflicting reports? I don't know how you lawyers call this.
It is, if it is on the same subject matter, but if it is on a different subject matter, then there has been a separation between the two matters. Apparently, what I see here is an attempt to just do the will of the State Security Services by all means possible, even if it means going the roundabout way.
Okay.
But if they come this way, then you could find that objectively, there is a window, there is a space within the law for them to want to seem to justify what they did, as AFNAIA is seeking to explain. Now, if a suspect is arraigned in a court, let's say a high court, for a particular offense known to law, and then another allegation of commission of an offense, particularly if it's not related to this earlier charge, that suspect can be taken in for another charge. An individual can be standing trial, multiple trials in different courts.
Okay.
So in that situation where a particular individual could stand multiple criminal trials in different courts, then you could find a situation where if the facts exist prima facie on another charge, on fresh facts, yes, then the arresting and detaining authority can actually approach a magistrate court. So in this case, it is not the same case where you raise the issue of hierarchy of court, because it's entirely a different matter. If it's a different subject matter, a different issue, then of course the arresting authority, it could even be another arresting authority. But even if it is the same arresting authority in connection with the first trial, of course they can detain a criminal suspect on in relation to another matter. And then if that detention is going to exceed the constitutional limit, then they can approach the magistrate's court for that statutory order of remand. And if it is granted, then they can so remand that person if it is in their custody.
Okay, so let's quote Afunayana as seen on the Vanguard. He said, in 2022, the service commenced the investigation of Mr. Godwin Emefiele on suspicion of terrorism, financing, money laundering, among others, and subsequently applied to the Federal High Court, Abuja, for his arrest and detention. But the Chief Judge objected to the order and clearly stated that the service did not need an order to investigate or arrest him. Emefiele was to later obtain a restraining order issued by Justice M.A. Hassan of the FCT High Court against the service. Instructively, the DSS obeyed this order and did not arrest or detain Emefiele. However, on 9th June 2023, Emefiele was suspended as CBN governor by the president based on new information and suspected criminal infractions. The service, as expected by law, arrested and detained him using a magisterial order. Now, on 10th July 2023, Justice Amza Muazu of the FCT High Court, while recognizing that the DSS had every legal right to arrest, detain and investigate Emefiele, ordered for his release or prosecution within 7 days. Now, the service expeditiously and expressly complied with the order and charged him for illegal possession of firearms and ammunition being one of the criminal suspicions. Now, the Muazu order had, by implication, extended Emefiele's detention by 7 days with effect from 10th July 2023 when the initial detention order had expired. Now, within that same period, Justice Bello Kawu of the same FCT High Court, while dismissing relief sought by Peter Abang, counsel to Emefiele, on the 14th of July 2023, ordered for the release or prosecution of Emefiele within 48 hours. However, the service had complied with the 7 days ultimatum issued by Justice Muazu. In obedience to the rule of law, Emefiele was arraigned before Justice Nicholas Owebo of the Federal High Court, Ikoyi, Lagos, on the 25th of July 2023 for illegal possession of arms and ammunition. The service had long issued a press statement about the incident that happened at the court between its staff and those of the Nigerian Correctional Service, and then it goes on and on and on. And then it says, as normal with criminal investigations, security agencies rearrest suspects when there is adequate suspicion of commission of a crime, as may be revealed by ongoing investigation. So from this report, can we then say that the DSS has followed the right procedures?
One may be tempted to want to agree with Afunaya if these facts are verifiable, and then if what he's saying is what they did. Because yes, truly, like I said earlier, if a criminal suspect is standing trial on a charge before a court, that charge is clearly distinguishable from any other charge. As a matter of fact, even in the same court, let alone in a different court, and at different times, not the same incident. And that's why the particulars of any criminal charge will indicate what offense it is that the person is being arraigned, and then where it took place and at what time. Once it is different and it's not connected in any material particular with another charge, it can be separate and even taken to a different court. So if the State Security Service is saying, where they were asked to or ordered to arraign the person of God Emefiele within a particular period, and they did so and arraigned him for child possession of firearms and ammunition. And then if there's another fact probably available to them, and then that justifies investigation, then of course they are not restrained from doing that. But my point, one point I want to really raise here is, I wonder what our security agencies, particularly arresting and detaining authorities, enjoy in arrest and detention. Let me state some fact here. It does not matter the number of arrests and detention upon a criminal suspect with relation to establishing the allegation of commission of a crime in terms of prosecution. The arrest and detention does not aid you in prosecution.
Mr. Ekine, can we pause? Can we hold that thought, because we've got a commercial break? So when we come back from that commercial break, I would ask you a question relating to that thought of yours now, please.
It's okay then.
That's my life. So now you the sweet. Committee for the Defense of Human Rights, And we are talking about the DSS statement about its obedience to court orders, and we're looking at the legalese, that's the legal terms, legal languages used, and we're trying to understand it because a lot of us do think that the DSS does not obey court orders. A lot of us think that way, and now the DSS is saying it does obey court orders. I would like to hear from you shortly, but I've got a few questions that I will ask my guest, and then I will get to you, the listener. But first, the headline news, so stay tuned. Are you still there? Good evening to you.
Yes, good evening. I'm here.
All right. So yes, if you were listening, you're listening to 92.3 Nigeria Info Hard Facts with Kalada Korubatibo, and my guest is Ekine, National Legal Advisor, Committee for Defense of Human Rights, and we're talking about DSS obeying court orders, and we're focusing on their explanation as it concerns the suspended CBN governor in Mayfele. All right, so you were talking about something that aligned with the question I wanted to ask you. Do we need to detain somebody before we can rightly investigate them? Is it written in the law? Is it something that is a procedural, legal? Tell me.
No, not at all. Not at all. There is really no requirement that before. In fact, it's rather a lopsided procedure if you arrest before investigation, because upon allegation of commission of a crime, what the security authority is expected to do reasonably in the sequence of the procedure is to get into investigation, which is inquiry. And in that inquiry could actually even commence independent of the suspect. Several circumstances, scenes, and other individuals, and even the suspect himself, not necessarily detaining the suspect. So, but the delight that our arresting authorities would always demonstrate in holding citizens in custody is just what I think, for me, is worrisome. Now, let's even consider particularly the Emefiele's incident. Let's assume that the DSS is claiming now that they are obedient to orders of court, particularly with respect to arraigning Emefiele within the 48 hours or so that was ordered, and then they arraigned him on allegation of commission of an offense with respect to illegal possession of arms and ammunition. Now, the gentleman has been granted bail, right?
Yeah.
And in order to be in the custody of a state agent as well.
All right.
The Nigerian Correctional Service is also a state agent.
All right.
Holding this individual. Whatever excuse of emergence of new facts, whether on the same charge or on another matter, did not justify the action of wanting to take him by all means. That is the demonstration of the commitment to always want to arrest the person. So simply, Canada, there is no requirement that you must have a person. What's even the purpose of arrest? Fundamentally, the purpose of arrest is either to prevent the escape of a suspect, and where that escape is not just imaginary but real, or a possible interference with investigation itself. And that's why it does not matter for whatever justification. The Constitution has said, do not hold any person beyond 24 hours. Meaning that even if your investigation is going to span a week or a month or a case may be however long, don't hold a citizen of this country beyond 24 hours. Canada, I don't ask the 48 hours anymore because it does not even arise currently with the provisions in the Constitution. Because 48 hours will have arisen only where there is no court of competent jurisdiction within 40 kilometers radius. And 40 kilometers is not just a stretch from here to Rubukuru. So in most situations you will find even a court in less than a kilometer radius. So you should charge this person to court. So the idea of arrest and detention is not even contemplated to aid investigation.
Even when it has even when it has to do with national security, because that has also been one reason why.
What is the tangible threat? Like I said, it shouldn't be imaginary. It shouldn't be imaginary. To what extent that is real, that there will be threat to the Nigerian state, whether external threat or internal threat by an individual, except that individual is kept in custody. It has to be demonstrated, and that is why the laws today require that if you must detain a person beyond the 24 hours, it must be upon an order of court. And Canada, that application they are saying they approach the magistrate court is also heard. When you do that application for remand, the magistrate will still hear it. It is supported by an affidavit of facts. So if the magistrate is not convinced that that allegation or that demand, that request for detention is justified, it may not be granted. In some cases, it can actually be the suspect can be discharged at that level.
Okay.
So it is not expert, it's not automatic.
Okay. My final question before I let you go. So technically, I can dare say that the DSS has obeyed the orders given to it. Technically.
So Canada, I didn't just really want to go. When you disobey more of orders of court and you selectively obey one, you be described largely by your notorious activity. But in this regard, in context with what he has explained, the sequence where there was an order of court for them to arraign this criminal suspect that has been in their custody, and they said he complied and brought him to court and arraigned him on a two-count charge. Okay. Then again, that they were holding him in custody, and then they needed to extend the detention period and approach the magistrate court for a remand warrant or a detention order, and they obtained. That's the procedure known to law, no doubt about that. But like I said, it's not a justification to hold a citizen in custody before investigation. The authorities are in great numbers, even by the Supreme Court, that it is not a procedure known to law to hold a citizen in custody pending investigation.
So
this time when always having citizens in custody on the excuse of investigation is wrong.
So when you say that more cases have been disobedience than obedience, can you expatiate on that? What do you mean by that?
There have been several orders to the state justice services to release their criminal suspects in custody that they have refused now. Several. But these are many. Even the latest matter, their action, particularly before the presence of the High Court in Lagos, was a disobedience of an order of the court that just said this individual should be taken to the Correctional Service Center. And then just in a second, and you're insisting that individual should be taken to your custody.
Now, in defense, they say that it was due to overzealousness of both staff of the State Security Service and the Correctional Service. 1, 2. When it comes to Kanu, they said for every case that did not go their way, they went back to the courts to ask for a stay of execution, or I think there's another terminology that they use, but they ensured that they tackled it legally and never did otherwise.
Oh, quickly, if you are going to apply for stay of execution, right, it does not justify for the judgment debtor to refuse to act in that manner as directed immediately. Let me say, for instance, if judgment is entered, okay, the judgment or the order of court becomes valid immediately and effective immediately. Now, if you seek to either stay that execution within the window that is available for you, you apply to the court, but not to hold that person continuously in their custody. Let us assume that I applied for the release of a detained suspect, right, or detained citizen in custody of the holding authority, and then I got the order of court that I should be released immediately. What is expected is that that suspect should go home from that court hall immediately.
No.
Now, if for any reason you have fresh facts to rearrest that citizen, you can always arrest him. But anything otherwise to frustrate the enjoyment of the fruit of that order or that judgment at that time is a disobedience. Like I said, it's different from an appeal. That is why even when a judgment is entered, if you are to appeal against that judgment, you quickly run to the appropriate court and take the appropriate procedures of filing a notice of appeal. Even at that, it has not overturned the decision of the court. It's until the appeal court has entered a decision otherwise. The same way, an application for stay of execution does not stay execution of an order of court. It's until it is heard and granted. So why would you be holding a person in custody in the guise that you have filed an application for stay of execution? It is unknown to our law. That's not the procedure. That application for stay of execution alone in itself does not, without law, does not enable any person to disobey the order of the court. It's until that application is heard and granted.
All right. So let's listen to Afunaya yet again. Now, quoting him as seen on the Vanguard, whether on Emefiele, Bawa or Kanu, the service has obeyed judicial orders and handled the cases procedurally and in accordance with the rule of law. Critics are encouraged to be a bit more discerning and up their research capabilities. Doing so will reveal that the service obeys orders. Now, the Court of Appeal judgment on Kanu is recommended for detailed study, he said. Now, maybe we can decipher the difference between discharged and acquitted and what the use of either or both mean in the final order of a judge. The DSS is an ardent respecter of the law. Anyone may argue this, but it is true. It is in this regard that it has applied for either a stay or notice of appeal on some of the matters. One who does not obey the laws will not resort to legal procedures like the DSS has done. What's your reaction to that?
Yes, legally there is a difference between discharge alone and then acquittal with respect to the effects of how it probably will open a further prosecution of the same person on the same subject matter. Where you are tried and acquitted, you are immune constitutionally. You are not to be tried on the same matter by any other court or even arrested on the same subject matter anymore. But where you are merely discharged, right, of an allegation, and you are not acquitted of it, you may be rearrested and even tried again on that subject matter. That's the legal difference and the implication of a discharge and an acquittal. And that's why even when lawyers in court are making an application, we are very, very careful and then make sure that the application you are making before the court, if it is the one that should acquit your client, you should be able to say it's a discharge and acquittal. Because where the accused person is discharged alone, course, be prosecuted on the same issue.
So Kanu was discharged. So can we say there was no?
I wouldn't really know. It will clearly depend on the particular matter Peter Akmaya is referring to and what precise decision or judgment of the court was in that regard.
All right. Thank you for your time. Thank you very much, Ekine Esquire, the National Legal Advisor for the Committee for Defense of Human Rights. Thank you very much for your time.
Thank you very much, Kalada, for the opportunity. It's always my pleasure.
All right, then. You can join the conversation now. Now is the time for you to join the conversation. Let's talk. I would like to get your thoughts on this. DSS saying that it obeys the orders of the court, and you've heard the lawyer, and of course the human rights lawyer, and he has spoken and he has said it could technically they have technically, but there is no justification for holding someone while doing an investigation. That's the summary of our conversation. And he says that technically as well, that they may have disobeyed, in that split second or split minute or that 1 day, 2 days when they would have held the person in their custody, given that a judgment has been made. Is significantly disobeying a court order. But basically, the idea that we have generally when we talk about the DSS obeying court orders may not necessarily be the reality. Do you agree with that? 0817-923-0002, 0817-923-00003. WhatsApp messages 0809-0306-416, 0809-0306-416. And of course, I like to get your thoughts on this. I like to get your thoughts. I think we're live on Facebook and we're active on X, and we're live on YouTube as well. Let's get your thoughts on this and talk for development. I've got Wala calling from HA. Hello?
Yeah, Mr. Kalada, good evening.
Yeah, good evening to you. Welcome on the show. Let's talk.
It's Wala from HA.
All right then.
Yeah, I've been an ardent listener of Bad Facts.
All right.
In fact, I have to commend you, even though it takes my time since your colleague left.
All right.
You've been doing a wonderful job. I commend you for it.
All right, thank you very much. So let's
The issue on ground, really, I think it is better for Nigerians, and I as a Nigerian too, to really put a straight and correct legacy for the generations to come.
All right.
Whatever. Law is made for man to obey, and not the law to obey man. Mr. Kalada, with what is happening now, I cry for Nigeria. I don't want to go too far because I'm in pain.
All right.
Thank you.
All right. Thank you very much, Wala, for calling. Keep your calls coming in. 017-923-0002, 017-923-0003. This one says Mr. Emefiele committed atrocities against humanity and therefore should be punished accordingly. But don't you think the punishment should go according to don't you think the punishment should go according to the law? And that's why we're talking about it, legal procedures. Good evening all. What is the punishment for contempt of a court order? Who is supposed to enforce any punishment for such contempt of court order? If a judge finds an individual or an organization guilty, how often does it get enforced, especially against a government officer or a government agency? Text Uyibo. I think we answered this the last time. I've got Osarunobo from Elime. Welcome.
Hello, is this Nigeria Info?
Nigeria Info, it is what? Welcome. Let's get your thoughts.
This is my first time of calling.
All right, welcome.
Yes, I want to talk about the DSS issue because there is something I was going through online when a congressman in America was talking about the disobedience of the DSS on court order. The issue is that
in an American Congress.
Yes. They were calling on American Congress to look into the matter on the disobedience on court orders in Nigeria. So the issue is that we Nigerians have allowed this disobedience to exceed the boundary. Throughout the period of Muhammad Buhari, nobody actually talked about all these things.
But wait, let me pause you. Let me pause you. Do you really think that there is a disobedience of court order, given the explanation by the DSS and of course the lawyer that I spoke with not so long ago?
There is disobedience of court order. When there is a judgment that this person is discharged and acquitted, even if you are going back to court, you will first of all obey the court order. You obey the order first before going to court.
But what if the person was discharged and not acquitted? I hear that different. Discharging and acquitting are different. So what if the person was discharged and not acquitted? I mean, that's also another angle to look at it from.
If the person is discharged and not acquitted, you first of all discharge that person first. Before the acquitted, you can come back later. But in the case of acquitted, you don't have any right to come back later. But you first of all obey the court order that says discharge. Then you can go back to court later to apprehend that person.
Okay.
Not keeping that person inside and you say it's not acquitted or it's not that one. They are just using grammar to confuse us. First of all, discharge that person. Then you can go back to court later.
All right then. All right. Thank you very much. I've got Makwan from Imo State. Makwan, welcome.
Good evening.
Yeah, Makwan, welcome.
Canada.
Yeah.
This is my first time of calling you.
Welcome on the show then.
The issue is we also try to do things like the West, which colonized us. We follow their laws, we follow their system, we follow their pattern. I think that we are old enough to have created our own system and pattern that suits our way of life as a people. But nevertheless, the court orders that we have, there are many loopholes. As long as there are loopholes in the laws, the lawyers and the prosecutors and even the defendants will always manipulate those loopholes. Because there is a saying that says only those that know the law break the law. If you don't know the law, you don't perfectly break it. But when you know the law, those that break the law are those that know the law. So the DSS must have found the loopholes to manipulate. That's why they have right, if you go technically, to keep those suspects and their prosecution. So I think that is also the case. We need an overhaul in our judicial system. But that's not happening because the legislature, they are sleeping. They are just looking for allowances. They are the ones that would have looked for these loopholes and block them by having us a new constitution or amending the ones we have to block all those loopholes.
So do you think it's okay? The laws are there, but they are loopholes. You're saying the laws are there, but they are loopholes, so they should block the loopholes. Yeah.
Yes, because we can't do anything. Like these people will keep flouting the laws because of those loopholes. Just like the DSS lawyer said, he's very correct. All right.
Makwan, thank you very much.
The law, loopholes.
All right, Makwan, thank you very much. I've got Letambari from Bori and he's calling and he wants to hear his thoughts as well. Letambari, welcome. Let's talk.
Good evening, Canada.
Yeah, Letambari, welcome.
Yeah. My look on this issue is that now that we are busy perusing the activities or where wrong or right the DSS put through, whether it was right or wrong, I come to remember when Amefule was busy giving his financial policy and the Supreme Court gave a judgment, did he obey it? Now, the DSS is also following his own step while he was in office handling the situation. And now everybody is accusing the DSS of not following the procedure, not obeying court orders and all that. and we are failed to understand the role of Emefiele while he was in office.
So Letambari, so two wrongs will now make a right. Is that what you let's admit that Emefiele did what you said he did. Does it mean that we should not do the same? I mean, if you're complaining about what he did, then you feel like it's wrong, right? So why would you not want to do what he did just because you want to pay him back? Does that
That is why we will always remember the law of karma. That whatever you are doing, you will always remember this law of karma.
But you've just called it a law. You've just called it.
Look at those laws.
You've just called it a law now, because and that's why you should wait for the court, because the court is what will determine the karma. But anyways, Letambari, thank you very much. We've got a break and I've got to go. Sapi from Port Harcourt, sent in a text and said what goes around comes around, and if he didn't obey court order when he was CBN governor and the same. But I've got to go now.
For more talk, news and sports, stay tuned.